Hello, everyone, and welcome to our channel at Bradley Legal Corp. Today, let's talk about a really important topic: why asset protection does not work when it comes to divorce. I get this call a lot. Like I'm getting a divorce and I don't want my spouse to get my assets. So how can I keep them from getting anything? It's sad, but this is a common question. Well, first we need to understand what asset protection really is about. Asset protection is typically geared towards keeping your assets safe from third parties like creditors or lawsuits, like the people suing you to take your money that actually have no legal access to it. Now, when it comes to one spouse trying to shield or keep or hide assets from the other spouse, the analysis actually shifts dramatically. And here's the bottom line. If asset protection planning is done before the marriage, and it's properly maintained, then yeah, it can be effective. This, means that, those assets wouldn't be included in any separation or divorce settlement. However, the waters get very murky if the planning is done after marriage, right? After the marriage begins. That's where the rights of ownership and state laws regarding property division and community property come into play, especially when dealing with family law courts. It's critical to understand that any actions on your side to hide assets or avoid an equitable division of property are generally not just ineffective, but most of the time you're going to actually incur the wrath of the court. You see, judges possess considerable powers, including very powerful domestic relations orders, which can severely affect your rights. There are no lack of cases where courts have ruled against one spouse attempting to set up an asset protection plan in divorce proceedings or right before divorce proceedings. For example, we have the famous SEC versus Solo case that I talk about in my book, Overexposed, piercing one spouse's trust that the assets were transferred into, and then considering that trust as community assets or marital assets. We also have in re marriage of Duffy. Here the courts held that transferring assets to a third party to avoid equitable distribution is going to be viewed as fraudulent and subject everything that they did to be reversible. Similarly, there's in re marriage of Dorr. The court invalidated asset transfers made shortly before a divorce filing and deemed them to be, efforts to evade equitable property division. So you see, you need to understand the nature and presumption of community property, and that the assets that are acquired during the marriage and their growth and even the capital gain growth are going to be presumed community property. And the courts will want you and your spouse to actually come to an equal and equitable division of those assets with full disclosure of what you all have. And, they're going to force you generally to do this. You can't hide and shield assets from each other if those assets are presumed to be community assets. Now, after all of that, it is possible to create an asset protection plan after marriage, but before you got divorced, provided you're using clear, sole, and separate assets, not community assets. So talk to your divorce attorney about which assets are going to be classified as what. Then we can start working from there. But if you're contemplating this strategy, like right at the time of divorce, that's about to unfold, you're really too late to the game. Additionally, it's crucial to understand, again, the distinction between states with community property laws and those that aren't. This difference can heavily influence asset division during your divorce. So again, talk with the divorce attorney in your state. Have them clarify the character and classification of what the assets are, and then we can start creating the asset protection property plan and structure around that. So as a general rule, assets owned before marriage generally retain their separate property character during that marriage, and they often aren't going to be subject to division in a divorce as long as you never commingle those assets with the marital property. So, if assets like inheritance or gifts, become mixed with joint community property, they could actually lose that separate property status and distinction. So if you have significant assets and you're contemplating, a divorce and ending your marriage, this isn't really going to work. But if you're contemplating a marriage and you have assets, I would consider a prenuptial agreement, and that's going to be a really smart idea. These agreements actually help define property rights and expectations, and they're respected by most courts when you actually follow the proper procedures for them, when both parties have independent legal counsel and they're negotiated in good faith with full disclosure. And then we can, match that language in the prenup and the asset protection planning and trust, and then we can start creating it from there. Now, here's the best advice I can give anyone who's actually facing or about to face a divorce with assets. Don't submit yourself to the interest of a divorce lawyers and the court system. Both spouses lose in the long fought battle in the long run, with only the winners here in this situation being the actually attorneys who are going to bill you throughout the roof for the process. And I've seen this firsthand when I was a young attorney working in a prestigious family law firm that focused on a lot of the movie stars in Hollywood. If the marriage is truly over, educate yourself on your legal rights, consider the division of property, and if at all possible, negotiate the estate directly between yourselves, act like adults, and then get a third party, neutral mediator like a retired judge. And, this is what I did in my own divorce. It was very amicable, and we were done with the entire process for less than, $2,500. We maintained a relationship. And by doing this, not only will you save on significant amount of legal fees, but you will also more likely get through the process, more emotionally intact. And especially if you have kids added to this equation. So thanks for watching. If you found this information helpful, be sure to like and share and subscribe for more, insights on asset protection strategies and estate planning and myth busting. Take care.